Good morning, Mr. Shea.
Morning. May it please the Court. I'm Richard Shea, representing the defendant, appellant Thomas Smith. As the Court is aware, filed a brief in this first-degree murder case in which the defendant was convicted on a theory of premeditation only. That was the only theory that the jury was charged on, as well as some related firearms offenses. In reviewing the many points of argument that are raised in the brief, I feel satisfied that the brief has fully stated the facts and argument, and I have very little to add to the arguments which I have made.
Well, I have a question for you, Mr. Shea, if I could. What could the defendant have gotten from admissibility if the treatment records had been provided that he didn't have already? The witness admitted he was on drugs the night of the murder, and therefore the jury could assume that his perception was, or infer that his perception was somewhat impaired. What more would the jury have gotten from the fact that he was in treatment a month later?
The reason counsel pressed that at trial upon learning that this had happened, he only learned about it when it came up at trial. He thought that the treatment records, if they were gone into, would show that this witness was more debilitated by drugs than he had admitted to in his testimony in court.
But still, that's diluted by the fact that it would be a month later.
Yes, that was one of the reasons that the judge stated in denying the motion for mistrial. On another point, the Commonwealth has, I argued that the instruction that the jury could infer from use of a dangerous weapon, malice for purposes of murder, I argued that was inappropriate here, where the only theory submitted was was premeditation, and the first prong of malice had to be proved. The Commonwealth has cited Commonwealth versus Perez, which this court decided a few years ago, and after examining it, I have to agree that that does appear to control, and that my argument would require the court to reconsider the Perez decision in order to find this instruction erroneous. The only other point that I wanted to bring up was that I have made the argument that the various alleged ineffectiveness incidents of counsel dealing with witnesses should be considered cumulatively as well as individually, and I think that's particularly important, where you had the second of the alleged eyewitnesses, Mikey DeJesus, got up and testified and was examined extensively by the Commonwealth. Defense counsel chose not to cross-examine.
Mr. Shea, excuse me, I think in this case the motion for the new trial judge was the trial judge, correct?
Yes.
Okay.
And so there was no cross-examination. The next witness that testified was State Trooper Robertson, and she, with the agreement of defense counsel, recited a large portion of the defendant's statements to the police while he was incarcerated in New Hampshire. He was interviewed twice. She was allowed to, the prosecutor was allowed to lead her through the statements and essentially recite portions of the statement to her and say, and did he say that, and did he say that? Then it was only upon cross-examination that counsel for the defense first brought out the fact that Mikey DeJesus, when he had talked to the state trooper, had initially denied that he had been present at the scene of the shooting, and that he in fact had gone inside before the shooting, and he heard gunshots coming from the outside to where he was inside. So my point is that if you consider these two alleged ineffectiveness points together, the sequence of DeJesus testifying heavily against the defendant on direct, no cross-examination, the state trooper being led through the defendant's statements. And then only after that did defense counsel bring out the fact that the eyewitness to Jesus had initially given a statement denying that he had seen anything, that the effect of that impeachment of DeJesus was lost by reason of the sequence of the testimony that I've just recited.
But how can we say that that was not a strategic judgment, that it was more effective to have Jesus off the stand and then later have the jury learn that he had initially denied seeing what he just testified to?
Well, the reason I'm arguing that is, in this instance, putting those two witnesses together, having the trooper testify to that came only after she had changed, the subject had changed significantly to the defendant's exculpatory and inconsistent statements to the police, which she was allowed to go into at great length through leading questions. So it's the timing of the impeachment was detrimental to the defendant here. And secondly, if you look at the cross-examination of the first eyewitness, Chico Barros, there was counsel did a very good job of leading him through all sorts of inconsistencies in his various statements, which certainly diminished the credibility of the witness, and there was no direct challenge to the witness, the second witness, DeJesus in this case, which could have also diminished his credibility in the eyes of the jury. Instead, it came in the kind of cut and dried, two-dimensional testimony of the state trooper later on that, yes, in fact, he had given a statement that he hadn't seen anything.
Thank you, Mr. Shea.
Thank you.
Good morning, Mr. Gold.
Good morning. May it please the Court. David Gold for the Commonwealth. Your Honors, just to respond briefly to my brother's last point on cross-examining one of the Commonwealth's eyewitnesses. As the motion judge found, as you pointed out, who was also the trial judge, the eyewitness, this was of course a strategic decision not to cross-examine, and to the extent that there was impeachment material to be had, this was done through the cross-examination of Trooper Robertson. Briefly, as
I ask you a question with respect to the failure to disclose the promises, rewards, inducements. How did that come about?
Yes, Your Honor.
How was it that the government was unaware of, or the prosecution was unaware of this and didn't disclose this?
Sure. The record shows that the prosecutor was aware at least of one night of being put up at the hotel, that these two eyewitnesses, according to the prosecutor, were in harm's way, and that he, along with the state police and the Taunton police, believed that getting them out of the projects was necessary. Defense counsel was given the weekend. I believe this occurred on a Friday. And defense counsel was given the weekend to investigate. And then it became clear when the prosecutor was able to speak with the police officers that actually they were put up at a hotel for longer than one night. In fact, one of them was 6 nights, and the other one, I believe, was somewhere less than 6. I think it was 3, I'm sorry. And he provided this information to the judge. He submitted an affidavit explaining the circumstances, which included letters sent to the police during the pretrial discovery phase asking for any promises, awards, and inducements. So in the end, the prosecutor learned over the weekend and provided that information to both the judge and, of course, defense counsel. So that was the context.
And the additional thing was the Commonwealth's assistance to one of the witnesses in getting into a drug treatment program?
Sure. There were several things, Your Honor, although the defendant's motion for mistrial was based exclusively on the transportation of Barros to the treatment center and back the next day.
Okay, so the only assistance the Commonwealth gave with respect to the treatment center was they transported him back and forth one day?
I hope I didn't, I might have misspoke. The Commonwealth did provide assistance to Barros in addition to the treatment. The defendant's motion for mistrial was related to the fact of learning the fact that Barros had received treatment and the Commonwealth's transportation. The Commonwealth also provided money for food to both of the eyewitnesses, again, provided them with the stay in the hotel.
Did the Commonwealth, I guess the point I'm trying to get to, and I apologize if I'm not being very clear, did the Commonwealth essentially get this person into the drug program?
The record, I'm certainly not aware of it, and the record is not clear on that point.
I have a question about the stipulation. Did the stipulation say that the Commonwealth paid for Barrows to stay at the hotel?
Yes, the stipulation certainly said the Commonwealth paid for both witnesses to stay at the hotel.
See, I'm looking at page 21 of the brief, and it had me confused because the stipulation said that the Commonwealth and the defendant agreed that DeJesus stayed at the hotel and that he stayed there at the expense of the Commonwealth. And then 2 paragraphs later, it says number 2, Francisco Barrows stayed at the same hotel. Then there's ... so I can't tell whether you've omitted that the Commonwealth paid for him.
Yes, Your Honor, in the transcript itself, at the point when the joint stipulation was being read to the jury, the judge asked the Commonwealth, did you also pay for that night at the hotel? And I believe that's why the ... are in the brief, that there was an interruption essentially in the joint stipulation to clarify that the Commonwealth paid for that.
For Barrows.
That's right. The jury was made aware that the Commonwealth paid for both witnesses to stay at the hotel.
Thank you.
Now, this came out after the defense had closed. I mean, after the evidence was over, correct?
That's right. It came. This came out after the jury charge conference, after the Commonwealth had closed.
And I gather there was no request by the defendant to recall either DeJesus or the other witness.
No, that's not correct, Your Honor. The defendant did on that day, prior to, at the end of that day for the weekend to investigate, in discussing the weekend to investigate, request that Barros and DeJesus be recalled on the following Monday, along with Mr. Johnson, who was the person identified as giving the information to defense counsel. It is not clear from the record whether Barros and DeJesus actually arrived on Monday, but what is clear is that the judge read the joint stipulation and that the parties agreed to have the judge read the joint stipulation.
So we don't know if that was pressed or what really happened?
We certainly know that that defense counsel had but the prosecutor agreed to have them recalled as witnesses. Yes, I'm sorry, we don't know whether they showed up or if it was
But the
pressed.
court didn't say no, we're not recalling them.
No, the court definitely, as far as recalling them, the court subpoenaed them in the event that the defendant wanted to.
So the court was prepared to reopen the evidence
In the event the defendant wanted the evidence reopened, and the defendant and the prosecutor agreed instead to have a joint stipulation read.
And the defendant didn't say anything about wanting to call them, anything further about wanting to call them as witnesses?
That's correct, Your Honor. What the record does show is that Mr. Johnson was in the courtroom that day, and the defense attorney did not want to call him to testify. That instead he was going to rely on the joint stipulation. And unless the court has further questions, the Commonwealth will rest.
Oh, before we leave,
Sure.
the jury instruction. Why is it not? I know what we've said, and I know what the model jury instructions say, but why is it a fair inference that the use of a dangerous weapon reasonably suggests the inference that the person intended to kill the person, as opposed to causing grievous bodily harm?
Sure. I'm not sure how to answer that other than what you have previously said in other decisions.
No,
but-
I understand. We've got Perez, right? And then Perez is followed by Oliveira.
That's correct.
But, I mean, I don't have Perez here with me, unfortunately, but...
Sure. In Perez, it was almost if not an identical instruction and an identical argument. The reason that this is important, I think, that this court has found, and I would argue, is that this was done in combination with the premeditation instruction. And I think that that's important to consider, and also the fact that I'm sorry.
No, go ahead.
And also the fact that in the in the jury instructions in this case, that only the first prong malice was instructed when it was when the first degree murder by premeditation.
That's correct, but I mean, you don't dispute that you have to give intent to kill, not intent to do grievous bodily harm, right? Then we've got a whole bunch of dangerous weapons, like short feet, right?
Sure.
I mean,
yes.
here you've got a gun,
Yes.
which makes it, I suppose, a little easier. But a short foot, intent to kill.
Well, I agree that that's of course different than the gun, but as this court has found, and it's important to consider that this instruction was not given, as far as inferring the use of dangerous weapon, was not given in isolation. The jury is explicitly instructed on first prong malice. In fact, there's a case which I believe I cited in my brief, which is Jenkins, where the judge actually gave all three prongs of malice, and that was of course not the correct instruction. But even then, it was okay to use those three prongs in combination with the inference on the use of the dangerous weapon.
Where the Commonwealth is proceeding solely on the basis of premeditation?
That's right. In that case, the Commonwealth proceeded, I believe in that case, the Commonwealth proceeded on more than just the theory of premeditation, but the important part, but in instructing the jury on premeditation, the judge separately instructed on cruelty, but that in that context it was still acceptable.
Thank you, Mr. Gold.
Thank you.